we're at 11 a.m., so we'll get started. We've got an hour here today. So thanks everyone for joining us for today's webinar, Tipping in the Hospitality Industry. The BCHA typically holds these on a monthly basis. And today we're thrilled to have Ryan Anderson, partner at Mathews, Dinsdale and Clark, alongside Michelle Lee from LOC International to host the webinar. Before I hand things off to them, I just want to put up a quick poll today as the BCHA is looking for some feedback on a potential wage survey. So if you can take 2 seconds to fill out this poll that I've just put up, that would be very much appreciated. We are just trying to get a little bit of feedback to see if it's would provide value to our members. So appreciate you taking the time to do that. I'll leave that up for a couple more moments here. See the responses coming in. Thank you so much. Awesome. Okay. Well, without further ado, I'm going to hand things off to Michelle to kick us off. Thanks again for being here, everyone. And yeah, enjoy. Cheers.
Hi, good morning, everybody. I apologize. I'm a little bit under the weather this morning, but I sincerely appreciate everyone tuning in to learn a little bit more about cashless tipping, as well as the policies surrounding it for best practices. But I work with LOC International and look after all of our clients in BC. LOC handles everything related to in-room technology, but specifically, I'm here to talk about our latest edition, which is to provide cashless tipping to your properties. So without further ado, I'm going to share my screen. Are you guys able to see the screen? Okay, perfect. So earlier this year, we added the TechnoTip solution to our very large portfolio of in-room technology solutions. But funny enough, when I first started with LOC, I was prospecting on the islands, staying with one of my clients, and they actually did not have TechnoTip. They do now, but I stayed for about 4 days, going to different properties on the island, and I received amazing service. I always think that the independent boutique properties on the island always provide amazing service. But because I didn't carry cash anymore, there was no way for me to leave anything for the housekeepers. So I ran downstairs. They did have an ATM, but then it was out of order. So when I went to go check out, I asked the front desk if there's any way for me to add anything at all that'd be passed on to the housekeepers that took care of me during my stay, and they weren't able to do that. So I'm very happy that they're fully enrolled with the program, and from the feedback we've gotten, they're doing a great job with it. So essentially, it is a QR-based solution. So TechnoTip saw something missing in the industry where people aren't carrying cash anymore. It's become very digital. Everyone has a credit card, everyone has their Apple Pay or Google Pay. So it's really impacting some of the hardest working members of the hotel staff, which are the housekeepers. So that's why they started this program to ensure that they're still receiving their gratuity. Cash tipping is still going to be a thing, but for people like myself who don't carry a lot of cash anymore, they do have the option now to leave a tip. So I think the statistics is about 30 to 60% tipping decline, which is a big impact in terms of the earning potential for the housekeeping staff. It's also difficult and it feels a little bit bad, especially when you only have a little bit of change. So sometimes I'd rather leave nothing at all rather than the chicken change in my purse, if you've ever been in that position. So it does enhance staff retention. So this is a program designed to ensure that they're well received in terms of their wages. It's going to be the point where uh, housekeepers or any staff for that matter are going to be choosing between working for a property that they're able to earn a little bit more with a cashless tipping solution rather than a property that doesn't. So I know that a lot of properties are still facing a bit of a labor shortage here, so it could be a big differentiator when hiring. And it is also tied in with a Google review system. So in terms of valuable feedback, if a guest is happy, they're looking to leave a tip, they could leave feedback for the property itself. And then anything 5 stars and above will be automatically posted to enhance your Google reviews. And then anything below that, the feedback would be sent directly to whoever's managing the solution for your property to review. So it could be really valuable intel as well. So if you get maybe some sort of feedback consistently where the alarm clock keeps going off at weird times of the morning, you might need to replace your alarm clocks with single day alarm clocks. Or if guests complain that they're not able to use Netflix or stream what they want, you might want to look into upgrading your television systems. So it is very simple. So nothing to download in terms of apps. So I know there's so many times where if you need to use a specific service or even some of the TVs where you're able to stream, you have to download a specific app and then maybe you never use that app again. It's simply a QR code. You could put that in on your key cards, your key card holders, little 10 cards across the room. But I'll show you what it looks like from the guest view. If it's gonna let me click this, might have to take this out of. Okay, there we go. So this is an actual landing page that we did design for the Germain Group in Toronto. So you're able to personalize the landing page, so any sort of messaging or imagery that you'd like. And then we do have preset amounts for the tips. So 5, 10, 15, 20. Some of the more high-end properties had to reach back out to the operations side of the team to increase this amount because people were leaving like $150 tips, which is a good problem to have, I think. But you're also able to do a custom amount. So let's just say 12. And a good part of this program too is we're very transparent about the costs. So the only cost to the property is a small one-time setup fee. So usually $149, and that covers the customization of the landing page, the QR code, and everything to help get you set up with Stripe. And then just the administrative fee and then the Stripe processing fee. But most of the time, the guest will opt to cover that fee. So we let the guests know, hey, there's a fee to process this payment. Would you be okay with covering this as a part of the tip? Otherwise, it would just be deducted from the total tip. And they could put their specific room number and which team to send it off to, or specific employee names if they want it directly to that employee. And for the business traveler like myself, you are able to request an email receipt, which is great. I can be a little bit more generous during my stays with my clients because I could just expense that, right? So click continue, and they're able to pay either by credit card or it's tied into Google Pay as well as Apple Pay. So very easy. And then some of these, so as I mentioned, you're able to leave some feedback. So you could leave that. And everything is customizable. So some of the properties did opt to remove the feedback portion. They just said, don't really want to deal with that, just remove that. So you're able to choose if you want to or not. So one thing that we do mention to each client that we work with when setting up TechnoTip for the property is we do highly recommend doing a tip pool. Why we do that is it really encourages teamwork. There's no operational challenge where everybody has their own QR code and then you have to replace it every time someone new works. I stayed at the specific property for 4 days, so it just doesn't seem fair that the person cleaning at the end of my 4 day stay reaps all the benefits of the tips. So that way it's evenly divided. Most properties will do it hourly. So if they collected $1,000 during the 2 week period, or maybe they do it once a month, they're able to break it down as a value per hour worked and then divide it equally amongst who worked how many hours. So this way, you will get a little bit of pushback from the housekeepers about, we have to pay taxes on it, but it is the right way to do it. And I'm sure Ryan, during his presentation, he'll go into that a little bit more about best practices. So this is actually a report that we pulled. So you do get an email report either through the dashboard that will help set up for you and also by Excel. So you can opt to have an Excel spreadsheet emailed directly to payroll or whoever's managing the program on a weekly, bi-weekly, monthly basis. And as you can see here, so this is real data collected. If you see an even rounded up tip amount like $25, that does mean that the guest had opted to cover that technology fee. So more often than not, a happy guest is more than happy to cover that. So your staff get the full amount. And then this is what the dashboard looks like as well. So if you prefer to do it that way. And this is some of the collateral that we recommend you put the QR code on. So the properties with the most success with this program, they do have the QR codes in multiple areas. So whether that's with the 10 cards on the key card themselves or on the key card holder with a little message, we could customize it however you'd like. So some of the brands that have partnered up with TechnoTip, and just some feedback from the users of TechnoTip. So the Germain Group were one of the first ones to implement TechnoTip. The founder of TechnoTip actually went on to Dragon's Den, had the interest of one of the sisters who helped find an investor. And then we do use Stripe for the payment processing. So everything is very secure when it comes to the financial transaction. And just a little bit about Lock International. And that's pretty much it. It's very simple solution. This is my contact information if you did want to reach out to learn a little bit more. But I'm sure Gareth will share that after this webinar.
Okay, thanks for that, Michelle. I'll take it from here. As Gareth said earlier, my name is Ryan Anderson. I am a labor and employment lawyer working for a firm called Mathews, Dinsdale and Clark from our offices in Vancouver. We represent employers exclusively in every sector, largely almost exclusively private sector. Myself, I do a lot of work in the hospitality, food and beverage, tourism, and gaming. And this is a hot topic, tips, gratuities, in this sector. it's a challenging area, frankly. There's some conflicting information and some conflicting rulings. We have different experiences in different properties. So if you've worked at a property in Ontario, you'll see some differences in British Columbia. But frankly, even within British Columbia, we have different experiences. I meet all sorts of clients who say, well, this is the way we've always done it. We've done it this way for years. We've never had a problem. I think this is the industry standard, and are sometimes surprised to learn that they're not acting in compliance. It's also a really important employee relations issue. I mean, we're talking about their money. And when you're touching people's money, it's a sensitive topic, and it's one we want to get right. And it is really important to employees. So what I'm going to do is share my screen here. Let's make sure that works properly. Michelle, I can see you on the screen. Does that look okay to you? Looks good. Okay, so I'm going to give you a crash course here. I've got you until noon. I'm happy to take some questions at the end. I want to make sure I get through each of the 4 critical topics and then field as many questions as come in. I can stick around past noon for those of you who might want to continue to chat. The 4 most important topics are these. First, the fundamentals. We need to deal with the definition of wages and gratuities. There are definitions in the Employment Standards Act that are quite precise, and they are a need to know. So we'll deal with exactly what are we talking about here in terms of the statutory definitions, and then some rules about withholding those funds and making deductions from wages and gratuities and the restrictions surrounding that. And then tip pools. How do we lawfully implement a tip pool? Who gets to participate in a tip pool? Take a quick look at some case law, very quick, and then some best practices. Another really important topic in this area is service charges and surcharges. Some rules changed about 5 years ago in the Employment Standards Act, and we really have to get into the head of the customer to figure out how would a customer perceive this service charge or mandatory gratuity, and how do we have to manage those in order to be in compliance with the Employment Standards Act. And I'll talk about some best practices there. And then the big question, to tax or not to tax, and that's the question of direct tips or controlled tips. And you probably saw some scuffle when a Ristorante Amano case came out about almost 2 years ago now. Not actually a brand new legal precedent, but it did certainly draw some attention and created some controversies. I'll help you try and make sense of all of that, and again, turn to some best practices and some solutions. So kicking straight in, some fundamentals, the definition. So the definition of wages under the Employment Standards Act is very broad. It's about anything that is paid to an employee for the performance of work. And it can be wages, hourly, it can be salary, it can be commissions, it can be piece rate, it can be bonuses. So any sum of money paid that in a relationship to hours worked or an incentive for productivity or efficiency, that's wages. But the definition of wages under the Act also explicitly excludes gratuities. And only just recently, relatively speaking, about 4.5 years ago, a new definition of gratuities was included in the Employment Standards Act, and it has 3 prongs. The first is a payment voluntarily made or made to an employee or left for an employee by a customer in circumstances where a reasonable person would presume that the customer thought this payment was going to go to that employee or be shared with employees. So voluntarily left directly for employees, that's a cash tip. The next category is voluntarily made to an employer by a customer in circumstances where a reasonable person would infer that that customer intended or presumed it was going to go to that employee or to a group of employees. So, but this case, though, it's paid to the employer, and that's an electronic tip. That's when the guest provides the tip through credit card or debit card. And then there's the third prong, which is a less voluntary approach, so to speak. It's a service charge or a similar charge imposed by an employer. Again, in circumstances where a reasonable person would infer that the customer thinks, yeah, I understand this is an 18% gratuity because I'm in a large group, or I've contracted for banquet services, but I'm still assuming that this money goes to the employee or the group of employees who served us, and that's obviously for service charges. So, these are very precise definitions that didn't reside in the Employment Standards Act previously, and it resulted in some changes in the way we have to deal with them. For the longest time, we've had Section 21 in the Employment Standards Act, which expressly prohibits an employer from deducting, withholding directly or indirectly earned wages from an employee for the purposes of covering business costs. So it's never been proper for an employer to say to an employee, you worked 8 hours, here's your rate of pay, but I'm deducting $5 for so-and-so. That's been prohibited under the Act for as long as we can remember. There's also, I've just finished telling you that wages has a definition and it excludes gratuities, but there's a provision in Section 21 that says, oh, by the way, if you deduct from gratuities for the purposes of covering a business cost, then those deducted monies will be deemed wages, even though they were originally gratuities. If you deduct them unlawfully, they will be deemed wages for the purposes of recovery. And if there's a complaint, the Employment Standards Branch and Tribunal has the jurisdiction to order you to repay those funds to an employee. So here's a list of business costs: breakage, spillage, spoilage. I won't read the whole list to you, but even if it is the employee's fault, the employee has made a mistake in the workplace, the employee has been reckless or careless, or even deliberately caused harm or damage or cost, the solution isn't at law deducting those costs from the employee. The solution is discipline or dismissal. And if the amount is significant, you take a civil action against the employee, but you can never act as judge, jury, and collection agent by saying, hey, look, you just cost me $50. I'm taking it off your paycheck. That's unlawful under the Employment Standards Act. And that applies equally to wages and to gratuities. There's an interesting one here as well at the very bottom: credit card or debit card processing fees. I think an employer rightly might say, look, at the end of a shift, an employee might have collected $100 in tips through credit card payments. But as the employer, I'm not going to get $100 back from this credit card transaction because I got to pay a credit card fee of 3%. So if I give it $100 back to the employee as a due back, I'm not actually going to be able to recover that entire $100. I should be able to deduct the credit card fees. In British Columbia, that is not lawful. And it's a bit of a confusing situation because if you study the Employment Standards Act carefully, the definition of gratuities includes those three prongs I just shared with you, but it also goes on to say, but does not include. So the definition of gratuities does not include charges as may be prescribed related to the method of payment used or a prescribed portion of those charges. That's about credit card fees. There is a provision in the Act that says gratuities doesn't include prescribed credit card fees. The problem is nothing has been prescribed. This is the way legislation sometimes works. You have an act, which is the primary piece of legislation, and then you have regulations where prescribed details are enacted through the legislature. Right now, what this is essentially is a placeholder. It's possible that one day the government may prescribe a formula that allows you to deduct credit card fees from the electronic tips, but the legislature hasn't done that yet. Compare that to Ontario. In Ontario, there is a prescription, a prescribed formula in the employment standards regulations there that says that you can deduct the greater of the credit card fee or 1.5%. We don't have that in British Columbia. So as a bottom line, employers cannot deduct credit card fees from electronic gratuities. Now, in addition to Section 21 that says you can't withhold earned wages from an employee for any purpose, here's a companion provision that came in 2019 that makes it even more clear when it comes to gratuities. And it says just this: an employer must not withhold gratuities from an employee, make a deduction from gratuities, or require an employee to return or give the employee's gratuities back to the employer. So that's crystal clear and easy to understand. And of course, in order to allow for tip pools, there is another provision, which is 30.4, which makes an exception. There's a couple of exceptions. One is you're allowed to deduct from gratuities when you're authorized by some other law, like garnishment or a family maintenance order. But in particular, the Act following 30.3 is 30.4, which makes provisions for tip pools, which of course we'll talk about next. So in terms of the lawful imposition of tip pools, we look at 30.41, and it says, despite 30.3 that says you can't withhold from gratuities, you can make a deduction from such gratuities or require the employee to return them if the employer collects and redistributes gratuities among some or all of the employer's employees. So this effectively authorizes the employer to arrange for a tip pool. Now, the next question is, who is permitted to set the tip pool formula? So for some guidance on this, we go to what's called the Interpretation Guidelines Manual, which the BC Employment Standards Branch publishes and helps us interpret the Employment Standards Act and regulations. And it says that an employer can require employees to pool their tips and share those with folks in other positions that would otherwise have no access to tips, but a reasonable person would assume they should share. So that's back of house, for example. And those guidelines give an example. They say an employee here's an example. An employer requires all of its employees who receive tips to put 15% into a tip pool. It's distributed to those who don't normally get them according to a formula agreed to by employees. It's interesting that the branch has decided to use this example and specify that the formula is agreed to by employees. That kind of begs the question, is the employer permitted to set the tip pool formula? And the answer is yes, the employer is allowed to set the tip pool formula, the percentage for back of house, front of house, the total, all of those things. The employer can do it, but the next question is, should the employer do it? Should the employer be in charge of this? That takes us to the CRA. So it's all about controlled versus direct. And if you're in this industry and you've been thinking about tips at any point in your career, you've thought about this before. The CRA says, with respect to tip pools, tips will be considered controlled if those tips are allocated to employees using a tip pool formula determined by the employer. So if you get involved and you set it up and you set the percentages and you manage the tip pool, then those are controlled tips. And that means it triggers a requirement for CPP and EI deductions and remittances at source, both employee contribution and employer, as well as tax. However, the CRA says with respect to tip pools, if the pools if the formula and the process is determined by employees rather than the employer, then they're direct tips. And that does not trigger a tax, CPP, or EI requirement. We're going to come back and talk more about that later, but it's an important decision about just how involved you want to get as an employer in arranging and managing the tip pool. The next question is, who gets to play in the pool? Who gets to participate in a tip pool? And there's a couple of different ways to look at this. Firstly, we look at the legislation. So 30.4 and its subsections deal with ownership in two different sort of categories. And I won't read this to you, but the first deals with corporate owners of the operation, and they're not allowed to participate in the tip pool unless they're performing to a substantial degree the same work as the employees who are in the tip pool, or other employees of other employers who commonly sort of industry practice, and I'll explain that more in a minute. So the first part of this deals with corporate owners, and the second part deals with more private owners, or the mom and pop shops. So if you're an individual employer, a proprietor, a partner in a business, you're also not allowed to participate in the tip pool unless you're regularly performing to the substantial degree the same work as your employees, or the same work as employees of other employers in the same industry who commonly receive tips. So think of it this way. You might not employ a sous chef, but as an owner, you're performing the functions as a sous chef. And at other employers in this industry, sous chefs often participate in a back of house tip pool. So if you're performing the same work as an owner, then you can participate in a tip pool. You certainly don't have to, and you have to decide from an employee relations standpoint, should I? Often the answer is no for a variety of employee relations considerations, but this is how the legislation makes an exception if you're doing the work. That's about ownership, though. What about managers and admin staff? The legislation is actually silent on that issue. And so we look to the case law, and the most recent and relevant case was from 2021, which was the Retail Action Network and Anna Gerard. And quite simply and bluntly, assessing the legislation, the tribunal determined that there's nothing in the Employment Standards Act prohibiting a tip pool that includes, for example, managers and administrative staff. So you absolutely are allowed as a manager or as admin staff to participate in the tip pool. But again, it begs the question, is that a good idea? I think the answer broadly is probably not, unless that manager or administrative staff is really on the front lines, working side by side with employees and demonstrating that they're doing the same work, providing service, engaging with customers, because that'll be less offensive to the average employee who the circumstance of a manager sitting in the back office and not really being guest facing and not participating. The other question, of course, is if you're downloading the construction and design of a tip pool and the percentages, including who should participate, if you're downloading that responsibility and the decision making to employees, they might be less likely to say, hey, boss, maybe you should participate in this tip pool as well. And as a result, it's sometimes unlikely or unwise to have managers and admin staff in that tip pool. So in terms of tip pools, or takeaways here, is the best practices are restrict the participants to those doing the work, those who a reasonable person would assume would share in the tips. So folks who are customer facing, and if they're not customer facing, they're part of the process. They're back of house folks who are preparing the meal, who are preparing the service, even if they might not be out on the floor. Generally better, as I've just described, to exclude managers and admin staff. When I say, download the responsibility of designing a tip pool and making decisions about who should be in and out and what the percentage should be, many of you who have managed employees are thinking to yourself, geez, I'm not sure I can give that responsibility to this group of employees. How do I do that? You can still participate. I always say, suggest and guide, but don't dictate, right? You can be a coach to your employees in terms of how to set this up and what it might look like. And here's some options for you to choose from. You can put pen to paper and give them some structure, but just make sure that the final decision is made by those employees. And consider establishing a tip committee. If you've got 15 people to deal with, it'll be difficult to get consensus, but maybe you find 2 or 3 leaders in that group and you say, okay, what you should do is form a tip committee amongst yourselves, and I'll help guide those folks. And keep a record of this. It can be really simple language, but the best tip pool arrangements are the ones that say it was October of 2023, and the tip committee included the following people, and they came to the following decisions, and here are the rules, and here's their signature. And then it says, we're going to revisit this perhaps in a year's time, and then sign it, have them sign it, of course, not necessarily you, and then laminate it and keep it. The reason is you want to have a lasting record that this was employee driven. What happens in this industry, in many industries, is you have turnover. The folks who designed it are gone. The next person who is hired doesn't know anything about the process that led to it, and they might just assume that this was imposed by the employer. So if somebody from the Employment Standards Branch engages them and says, what's happening with your gratuities, that new hire might say, oh, this must be the employer forcing me to do this because I don't know anything different. It's good to have a lasting record of the genesis of a tip pool and to be able to demonstrate that it was really driven by employee decisions and not imposed by the employer. So that's a crash course in tip pools. Let's talk about this other really important issue in this industry, and that's service charges and surcharges. There are some really important and relatively new employment standards rules, again, about 4 years now, but in relative terms, that is still pretty new. And what used to happen prior to 2019, we always knew that it was unlawful to make deductions from wages or gratuities to cover business costs. We knew that. But the term gratuity, as I've just shared with you earlier, was not defined in the statute prior to May of 2019. And so there was this gray area. It's maybe less gray if you're dealing with, a group over 10 where you say there's going to be an 18% gratuity imposed, because that in a restaurant setting, for example, still looks and feels like a tip, even though it's imposed. But it's a little grayer when you're dealing with banquets, for example, where you've got an 18 or 21% service charge imposed in that kind of a setting. And it's quite common that if you've got, and here's an example from sort of pre-May of 2019, all food and beverage functions are subject to a mandatory 18% surcharge. It was really common practice, and it is, for that idiom employer in these circumstances to not put that entire 18% back into a tip pool, but to say, and probably very transparently say to the employees, look, there's an 18% surcharge for these banquets, but we're only going to put 12% of that, or 12% into the tip pool. The rest is going to be kept for administrative purposes, maybe to supplement manager salaries, maybe to deal with other costs. And because there wasn't a precise definition of gratuity, this kind of fell under the radar. Things changed in 2019, and I'm bringing up this definition. This is the third prong again. Now, the definition of gratuity includes a service charge or similar charge imposed by an employer in circumstances where a reasonable person would assume that that's going to the employee or a group of employees. This creates an accruing liability. If you've got 18% service charges applying and you're keeping a portion of that for administrative purposes, now we got to get into the minds of the customer, or at least how a reasonable person would view the mind of a customer. If the customer thinks that all of that 18% is likely going to the employee or employees, but it's not, you now have a breach of the act. So the test is simple, essentially. Would a reasonable person be likely to infer that the customer intended or assumed that all of the payment would be redistributed to an employee or a group of employees? If that's the assumption, then all of the payment will be deemed to be a gratuity, and deductions from that amount will be unlawful. So we learned pretty quickly in 2020 or 2019 and 2020 how to fix this. There were a number of complaints to the Employment Standards Branch and a number of resolutions without the need for a hearing and particular liability, but we needed to move fast. And here's what we did. Clarity is key. If any portion of a service charge or a surcharge is going to be kept by the employer, that's fine. You can do that. It just needs to be made explicitly clear. And here's an example that has been vetted by the Employment Standards Branch in British Columbia and deemed to be lawful. And here's an example. All food and beverage functions are subject to a mandatory 18% surcharge plus applicable taxes. Now we get clear, of which 12% is a gratuity that is distributed to our servers and as appropriate other support staff. The remaining 6% is an administration fee retained entirely by Ryan's Lodge. I don't actually have a lodge, but if I did, I'd keep 6% for administrative purposes and not distributed as wages, tips, or gratuities to any employee. So now you're making it crystal clear to the customer what portion of this surcharge is a gratuity and what portion is an administrative fee, and it avoids that potential accruing liability. An easy fix, but really, really important. Without it, you are withholding tips on every transaction and accruing that liability. So that's important item number 3. And now let's get to sort of maybe the big one, which is, to tax or not to tax. And it's a question of who is in control here. And we'll talk about the sort of fly in the ointment of Ristorante Amano. But let's start at the end. There are essentially 2 overlapping tests here. One is used by the CRA and one is used by the courts. They're not perfectly consistent. There's some overlap, so let's talk about that. From the CRA's perspective, the primary focus is who controls the tips. Are tips controlled by the employer before they're paid to employees, or are they controlled by the customer and employees? The courts are less concerned with control and more concerned about possession. Was the money paid by the employer to employees? If it was paid by the employer to employees, then it's taxable and it triggers EI and CPP obligations. The way this works practically is that if you can meet the first test, you're never going to see the second test, right? You're never going to be in court. If you can satisfy the CRA and you never run into trouble with the CRA about your handling of gratuities, you're never going to have a dispute that would make its way to the courts and deal with the second test. Now, it's important to know them both, and it's important to get as close to full compliance with them both because there is some overlap, but this is where some of the confusion settles in. So again, the first test, if you meet that, you're not going to be as concerned with the more stringent courtroom test, but it is easy to fail the first test. So let's talk about this in some detail. First things first, and this is all as per the CRA, tips that an employer controls or possesses. It's not like the CRA ignores possession, but they deal with it in a nuanced way. Tips that an employer controls or possesses and then pays to the employee are controlled tips. So if you make it mandatory service charges, mandatory tips are controlled tips and must be taxed. That is applicable to a banquet setting, it's applicable to events, it's applicable to a large table with an imposed 18%. If you're imposing a tip, then you're controlling your tip regardless of how you handle it, and that is taxable at source and triggers EI and CPP deductions. If it's a tip pool, I've already talked to you about this, if it's a tip pool where the tipping sharing formula and the who's in, who's out decisions are determined by the employer, that's a controlled tip. Then you have to tax at source, CPP, EI. If you include the tips within your business income and then you redistribute it, so there's a degree of possession. CRA is still concerned a little bit about that. If you intermingle it with your other bank accounts, then that's going to make it a controlled tip. If the employees turn it over to all of it to the employers, but that probably means the employer is governing the tip pool, for example. And then cash tips that are deposited into the employer's bank account and become or are intermingled with the property of the employer and then paid out are controlled tips. It's important here to note from a possession standpoint that the CRA is distinguishing cash tips. So if you took cash tips, put it into your account and then redistribute, that makes it a controlled tip. And that's because the CRA views the electronic tips somewhat differently. Here's an example from the CRA's website that says you're part of the restaurant staff, you receive tips. However, some of the support staff feel they should share those tips. So the restaurant owner agrees to put in place a tip pool and make sure tips are distributed amongst members. Clearly the inference here is that the employer is managing and dictating a tip redistribution process, and that makes it a controlled tip. And so the CRA rules are that, look, if it's a controlled tip, then it's part of the employee's total remuneration in addition to wages. The employer is considered to have paid these amounts if it's controlled, and that triggers the obligation to deduct and remit income tax and to do CPP and EI premium deductions and remittances. So that's how the CRA approaches the question of controlled tips. Direct tips, on the other hand, are tips that are paid directly by the customer, where the employer has no control over the tip amount or its distribution. And the CRA likes to use the phrase, the employer is merely a conduit for the tip from the customer to the employee. So there is the simple approach, which is they leave the cash on the table, they hand it directly to the employee. There is the redistribution approach, where it's the employees and not the employer who decide how tips are redistributed. And then here's the CRA nuance. A customer includes an amount for a tip when paying the bill by credit or debit, and the employer returns the tip amount in cash to the employee at the end of the shift, or in exceptional circumstances, the next day, if there wasn't enough cash available. These are the words from the CRA website. So clearly, the CRA allows for a brief period of possession. Yes, the employer holds the amount. Yes, it goes into an employer account, but as long as the employer turns that money around very quickly back to the employee, then it will still be considered a direct tip. Here's an area where a lot of operators are not compliant. If you show me 5 or 10, I bet you half of them are not compliant or are on the edge. The practical reality is it's just difficult to cash out, to do due-backs at the end of the day, particularly in environments where your last service is 11 p.m. or it's a bar where the last service is 2 a.m. People want to go home. They've wrapped up, they've cashed out, and it's difficult to do the tip out, to do the electronic tips turned into cash and calculated and paid to employees or paid into a tip pool that night on a day in and day out basis. But recognize what the CRA is saying is that it's meant to be paid at the end of the shift or in exceptional circumstances. So it can't be every other day or every week, because that's not exceptional. It can't be a routine practice. And I see lots of employers who say, no, we do it, it's 48 hours, never more than 48 hours, or it's every Friday. And they've never had an issue. And sometimes they just sort of keep on keeping on. But you are creating a liability if you're not complying with the CRA's expectation that tip out, that due back, is completed before the end of the shift. And again, here's their example. Again, cut and pasted from the CRA's website. You're part of the serving staff. Owner informs you that if a customer pays by credit debit card and includes a voluntary tip, the restaurant will return the full tip amount back to you at the end of the shift. And the CRA says that's compliant, that's a direct tip. But again, they're emphasizing end of shift. So again, the rules are, if it's a direct tip, it's not considered to have been paid by the employer. Therefore, there is no obligation to deduct at source any income tax, and it doesn't trigger any CPP contribution or EI premium obligations because it's not paid by the employer. So those are the rules as far as the CRA is concerned. And it's pretty simple. Cash tips are easy. It goes into the employee's hands and the employer didn't pay it. An employee controlled tip pool is relatively easy, and you have to help the employees set that up and they have to run it through a tip committee or otherwise. But again, those rules are straightforward. Credit card tips are still pretty easy if you can pay fast and comply with that cash out by the end of the shift. And if you do all of that, the CRA says, their favorite phrase, the employer is merely a conduit for the tip for the customer to pay the employee. And that all makes some sense until the courts get involved. Now, Ristorante a Mano is a federal court of appeal case. It's not actually a new precedent. It's the most recent case, and it drew a lot of attention, but it didn't really change the law. It just drew a lot of attention to the law. And here's how this goes. Very briefly, the facts in this case is Ristorante a Mano set and imposed a tip pool. That is, the employer controlled tips. And this is what got them into trouble with the CRA in the first place, because they treated those tips as direct tips, but they didn't follow my advice in this particular instance. I didn't really know them. But they blew the controlled versus direct by setting and managing and imposing the tip pool. So they weren't making any CPP or EI deductions or tax, and a CRA assessment found that those deductions and remittances should have been made because the employer set the tip pool. They were controlled tips. Now, Ristorante a Mano didn't like that, so they appealed, and they appealed to the Minister of National Revenue and then Tax Court, and the matter found itself into the Federal Court of Appeal. And the Federal Court of Appeal took a very, very black and white approach to this. They said, look, when money is paid by an employer in respect of employment, that triggers CPP and EI obligations. They say the word paid deserves a very broad interpretation, and they applied a test very simply, whether it was the employer who paid, and they say liberally construed, the tips to the servers. And the electronic tips, the court said, were not paid to or otherwise in the possession of servers. Rather, they were paid to the employer, who then paid the employees. Now, it was a frustrating case because in this case, being a reconsideration of already established law, the folks who argued the case said to the court, now would be a good time to revisit the rules that were set decades ago when cash was king. It wasn't very complicated. This whole possession wasn't so hard when customers paid in cash and left cash. So why are we applying rules and an approach that was designed in an era that doesn't exist anymore? I think you'll tell me probably well over 90% of your customers pay by credit card, and maybe it's a variation on that theme, but it's way more than it used to be. So these old rules shouldn't apply. And the court said, well, both the appellant and the respondent invited the court to address the proper treatment of tips more broadly to bring clarity to the issue. In my view, this is neither desirable nor necessary. Thanks a lot, right? Here was a chance for the courts to sort of modernize the approach, but instead, nope, they just kept it dead clear. The test is clear. In each case, the question to be asked is whether the amount in question was paid by the employer to the employee in respect of employment. In other words, possession is key. Remember that the CRA says, look, as long as the employer is merely a conduit, we're fine. The courts say, nah, forget that. It's simple. If the employer paid it, then it's a controlled tip and it requires CPP, EI, and tax deductions. So that leaves us in a bit of a conundrum. And the question is, have the rules changed? And the CRA doesn't appear to think so. Restaurante Hermano has been out for some time now. The website guidelines have not changed. Here it is again. A customer includes a tip at the end, et cetera, et cetera. The tip amount is paid to the employee in cash at the end of the shift or in exceptional circumstances the next day. This is still on the CRA website. And every time I do a presentation like this, I check to see whether the CRA has changed its approach or guidelines, and it hasn't. And so that's why I say, if you stay compliant with the first test, if you deal with the control issue and you make the CRA happy, you're very unlikely to ever face the more black and white test of the courts. So it's not an insurmountable challenge. It just takes some really careful planning. You want to try and address both concerns. The first is control to satisfy the CRA, and the second is possession to satisfy the courts. And to some extent, the CRA as well, because as I said, they'll allow for a brief period of possession, but you got to turn that money around very quickly. So to sum up here and leave some time for questions, the best practices here is deal with them in sort of two stages. First is create and maintain a direct tip system. Now, by the way, I'll pause here to emphasize, this is all premised on the notion that you don't want the tips to be treated as wages, taxed, and so forth. I have many, many clients who decided, okay, forget this. I am just going to treat it as a controlled tip. I want to control the tip pool. I want to be in charge. And I'll just tell my employees, look, you were supposed to pay tax on this anyway. CPP and EI, that's a society obligation, and I'm just going to avoid these things. But for the employer who wants to maintain a direct tip system, you're establishing a tip committee, you're guiding but not dictating, you're keeping a record of that. Avoid percentage of revenue models and mandatory and direct or imposed surcharges, because that turns them into control for sure. Avoid promises or contractual commitments, because if you're making a contractual commitment, you're telling the recipient of that contract that you're in control and you control the contract. Again, make sure the payouts are done at end of shift, have enough cash on hand to make sure that's done, so you're complying with that temporary possession expectation of the CRA. And make the tip outs in cash to a tip committee rather than the individual. So again, the committee is controlling. And then in terms of satisfying the courts, a couple of different ways to do that. A tip committee trust or merchant account. I'm not going to get into details here, but if you study your Uber bills, you'll see there's separate payments. You're actually getting charged twice, once for the service and then a separate charge entirely for the tip. And that's them dealing with the possession issue. And then finally, at the end of my crash course, I probably sound like a bit of an auctioneer, consider third-party solutions. So third-party solutions help you deal with the possession aspect of this by having the tips go through that third party, not paid by the employer, but paid through the third party to employees through a cashless tip system. So with that, I'll stop, turn it back to Michelle for just a moment, and then take any questions.
Yeah, thank you so much for that, Ryan. Honestly, that reminds me of the time that I was dealing cards at a casino. There was no real clear communication on what to do with handling the tips. We did a tip pool. The casino managed it, but no one told pretty much most of the staff that they need to have it taxed appropriately, or we were pretty much in charge of that. Obviously, having been a server before, I always try to claim what I need to on my taxes, but there were dealers maybe working 15 years that didn't claim a single dollar, and the whole casino got audited. And because there's paper trail, it put them in a really difficult financial situation. So I think just being very clear about the expectations, being in line with your staff on how everything should be handled, and making sure that everyone's on the same page will provide the most success in any way you choose.
Great, thank you. Let me just pick a few of these questions out of the chat. And so here we go. If cash tips never go into the bank account, they're held by the manager and then distributed to employees, is that still controlled? Look, this all sort of exists on a spectrum. There aren't a lot of bright line answers, but the lower the degree of possession and control of the employer, the more likely is a finding of them being direct tips. So, holding them for the day, whether that goes into a cash register, whether that goes into some safe box, etc. If that's redistributed to the employee at the end of the shift, I think you're definitely going to be in the control area. If you're holding that money in trust for the employee, someplace other than a bank account, like it's a safe, like it's a cash register, you're going a little further down the spectrum. But again, I think you might say, I'm not paying this to the employee. I'm not intermingling this with my business accounts or income. I'm just holding it in a safe place for the employee. Again, probably arguable, but the faster you get that money into the employee's hands, the more likely you are going to land in the direct tips category, if that's what you're after. Another question was, would it be considered reasonable for the kitchen to be part of a front of house tip pool? They aren't serving guests directly themselves, but they're employees. So I think absolutely yes. And look, it's sometimes, I think it's always a little bit of a challenge to get a group of employees to agree. If I'm a front of house server and I'm out there running around and I'm serving the guests and I'm dealing with the challenges of a guest facing job, some are very generous and understanding of the whole process and happy to give a portion of the tips they collect to the kitchen. Some are less happy. So getting to consensus on who should participate, kitchen staff included, and what percentage they should get, getting to consensus on that is sometimes a little difficult and sometimes requires a bit of guidance from an employer or a vote in some instances. But I think generally speaking, that is the expectation of a tip pool, is that the folks in the back of the house who are part of the experience and part of the process but not customer facing should still be able to participate and receive some of those gratuities. Can you use this? Can you use a system for both controlled and not controlled tips for restaurants that take cash? Yes. So I think on one of the slides earlier, I said if you're going to have mandatory, whether it's a banquet surcharge, etc., keep them separate. So be very clear with your employees in your policy, in your practice. Look, when we impose a mandatory tip amount, that's going to be taxed. That's going to show up on your pay stub. That's going to have CPP and EI deductions taken from it, because that part is controlled, but the other part is not. So you can have a two-pronged process. It needs to be carefully managed, but it's certainly doable.
There's also questions in the Q&A box as well.
Oh, okay.
There's a few now. Yeah.
Okay. Let me maybe Gareth, if you can take a peek at the Q&A, I'll pull a few more from the chat as well.
Yeah, sure thing. So we've got a question here. With controlled tips, would employers be required to pay vacation on those tips?
Great question. The answer is no. So wages attract overtime. Wages attract vacation pay. Wages attract severance pay. Gratuities that are taxed and that have CPP and EI deductions are done so because of tax rules, because of EI and CPP rules. But the Employment Standards Act still treats them as separate from wages. So it's the Employment Standards Act that imposes vacation obligations, overtime obligations, severance obligations, and that's the applicable statute. That statute makes it clear that gratuities are not wages for those purposes? And so the answer is no. Great question.
Okay, and are there restrictions to who can be on an appointed tip committee?
No, there aren't any at all, other than this question of control. So if the chair of the tip committee is the general manager, that's going to infer employer control. If the chair of the tip committee is a server, no problem. But it could be a server, could be a chef, could be a bus person, it could be a host, anybody.
Okay. And a question from Margarita here. We have due backs distribution every Monday, so once a week. Is that a correct practice?
So that's probably going to make it, from the CRA's perspective, a controlled tip, because the CRA's guidelines are pretty strict that the due back needs to be processed at or before the end of the shift, and only in exceptional circumstances the next day. So it appears the CRA is pretty exacting on that policy. So as I say, the CRA is primarily concerned with control, but they don't ignore possession. They allow for a brief period of possession to the end of shift or to the next day in exceptional circumstances. But waiting until the following Monday is almost certainly going to have the CRA say, no, that's a controlled tip. And I'll express, it's not very practical. Like, I mean, it's very difficult to, and I think employees will often be more than happy to have a consistent, on Monday, I get my tip out. That works for employees and it works for employers, and it's lawful. It just makes them controlled tips and would trigger an income tax, EI, and CDP obligation.
Sure thing. And a couple more in the Q&A box, and I see a few are trickling in the chat box as well. But if you have yet to receive the gratuities from a client, as an example, a convention, in the final billing, are you okay to withhold these gratuities until they are actually received?
Yeah, I think the answer to that is yes. The key here is possession of actual funds, and you don't have them, right? A promise to pay is not payment, and so I think generally, I'd have to sort of look at this on a case-by-case basis, but generally speaking, until you have the money, you don't have the money.
Right.
I see an interesting question here as well. I'll try to get all of them in the Q&A, but I've heard of grats, because I just mentioned this. I've heard of grats going towards severance. This seems wrong, is it? There's two different issues with severance. Under the Employment Standards Act, gratuities are definitely not included in the calculation of pay in lieu of notice. Under the common law, which is above and beyond the minimum standards of the Employment Standards Act, a dismissed employee might say, I don't have a contract limiting my severance entitlement to employment standards minimums. I want reasonable notice or pay in lieu thereof under the common law. And if you'd given me working notice, I would have received my wages as well as my tips. So yes, I want compensation for my tips as well. So that's an employment contract question, not an employee employment standards question. So to answer your question more precisely, you will from time to time see employees claiming gratuities as part of their severance claim, but they'll be doing that outside of the Employment Standards Act.
Right. And then I think just they seem to be coming through the chat now, but there was the last one in the Q&A was just, are we getting a copy of this presentation? And of course, we'll send all additional resources and copies of these slide decks through to everyone on this webinar following the webinar. It will also be uploaded onto our website and distributed through our newsletter too. So yeah, you'll have access to the recording of the webinar as well as copies of both Michelle and Ryan's presentations. Yeah, and there's a few more that have come through there in the chat. Ryan, if you've got your eye on that.
Sure, so let's do that. Make sure I get back to the top here. Bear with me. Is it okay to deduct any mistakes made by servers when they got the wrong amount on the payment, short payment? Generally speaking, no. So maybe the easiest way to put this is mistakes made by employees, whether it means they dropped a dish or they purposely smashed a dish or they forgot to charge or they undercharged or they didn't pay careful enough attention and the person dined and dashed. Mistakes by employees are a business cost and do not permit deduction from earned wages or gratuities. Here's another one. If changing controlled or direct pool percentages for employees, do you have to give notice to employees of a certain amount of time? Good question. The short answer is no. Not from a legal perspective. There's no prescribed notice period. It's not the kind of change that could lead to a constructive dismissal where you should be providing reasonable notice under the common law. This is really more of a practical question, is giving employees sufficient notice to sort of manage and deal with the employee relations. aspect of that kind of, if it's a material change and it's going to impact their income and their expectations, then certainly a couple of weeks, 3 weeks or even a month at most, might be a good idea from an employee relations standpoint, but there isn't any legal requirement for that kind of notice. So Gareth, you also search to see if I've missed any, because I'm talking and
Yeah, absolutely. I think maybe there was a couple missed. Sorry, I just had it, but oh, is there information to share on industry standard rate of tips for outlets, banquets, housekeeping, luggage porters?
yeah, I don't have a reliable answer to that question. I can share with you answers about rules and law, etc. But when it comes to sort of that kind of an industry data, my personal experience, and it's only anecdotal, it seems to be the 12 to 18% range, but I wouldn't take that as any kind of scientific study.
Okay, and then I'm not sure if this one got answered. If an employer processes all cash transactions and direct tips on the employee's paycheck, does that make them a controlled tip?
It probably does, because you're probably not doing that by the end of each shift, right? So by virtue of waiting until a paycheck, that means you're holding it and not paying it until some point, days or many days after the shift. So that would almost certainly make it a controlled tip.
Okay, sure thing. And then I think this might be a question for Michelle. If it all goes through TechnoTip, then it sounds like it is all controlled, therefore taxable.
For the most part, yes, but I believe it depends on who sets up the program. So I think just from Ryan's presentation, if you had someone from the committee use a separate bank account not associated with the business directly, and the servers or the housekeepers are managing the program, then it's not controlled. But if the property prefers to control and split the tips and manage that, then it would be controlled if it's using the business account. So it could be used both ways.
That sounds right to me.
Okay, and then a couple more just come through. If controlled tips are not correctly taxed and required deductions from the employee are not made, if CRA audits are performed, is the business required to pay the deductions?
Yes, and look, every case will be different, but in Restaurante Amano, their tax bill was over $100,000. And that's money that wasn't generated. So the liability that accrues can be really significant, and it's the employer's problem.
Okay, and last one, and in case anyone else wants to put any last minute ones, we've got, do kitchen support staff tip outs need to be distributed at the end of each shift?
They should, right? If you're trying to stay in the direct tips category and not have an income tax, CPP or EI obligation, then once you've set a tip committee formula that deems those tips theirs by the end of the shift, then they should be distributed by the end of the shift.
Okay, and one from Beth here. Do you have any recommendations on setting up an employee-controlled pool when the employees are not wanting to share anything with Support Kitchen?
Yeah,
how can we ensure a fair pool with it being employee-controlled?
And that's a problem that is faced by so many employers. There isn't a one-size-fits-all answer. And I'll just give you some anecdotal experiences. I've had a few where, with some guidance and some support from the employer about fairness, about industry standards, about recruitment and retention, they can draw a group of employees, or at least a majority of them, to vote in favor of a distribution percentage, and make them feel like it's fair. I have had others that are still in a sort of nonstop, we'll call it a battle, but a nonstop sort of discussion with their employees who just can't reach a consensus on how they want to distribute their tips, and which is in some cases why employers will throw their hands up and say, "I'm taking over then." Even more specific example, and I've had this in a couple of different properties, trying to recruit and retain, talented cooks and chefs is sometimes contingent on being able to get some of those gratuity funds into their hands, and the front of house servers are not willing to cooperate. And so their employers, at least in a couple of circumstances that I can recall, have decided to take control of the tip pool themselves, and okay, it's tax, and okay, it's EI and CPP, but I need to do this in order to balance the distribution and recruit and retain talent.
Okay. And then I think we'll cut it off after this last question. This one's from Teresa. If controlled tips are held and pay tax, can the owner split the tips however they like, i.e. keep a large amount for the business or leaders?
Well, that goes back to the rules in the Employment Standards Act. And so the permissible members of a tip pool are employees doing work, are managers and administrative staff, because there's no legislation on that. But there are two provisions in Section 30 that deal with corporate owners and individual private owners, where they can only participate in a tip pool if they are substantially performing the same work as the employees, who a reasonable person would infer would be included in the tip pool.
Okay. All right. Well, with that, I think we'll wrap things up. I just want to say thank you to Ryan for being here and sharing your expertise. Michelle, thanks a lot for co-hosting. Good to hear about TechnoTip and everything that you guys can provide in this area. And to everyone who is here with us today, thank you so much. And
if I can just add before we go, you'll have my contact information from the slide deck, which you're certainly welcome to. And if questions arise, I'm always happy to take a phone call. We don't need a retainer. We don't need legal fees, all those sorts of things. I do a lot of work in this industry. Quick one-off calls happen all the time, and I'm happy to take them without any charge.
Awesome. Okay. Thanks again, everyone. Take care. Have a good afternoon.
Thanks so much.
Thank you so much.